Hey everybody, Mr. Moffat coming at you again with another APGOV video. Once again from our series focusing in on topic 3.10, looking at social movements and equal protection under the law. Previously we have looked at civil rights issues regarding race, particularly African Americans, and gender, focusing in on issues for women's civil rights equality. Today we're taking a look at another area of focus, and this is taking a look at civil rights issues affecting LGBT Americans. Now, when we talk about folks that are in the LGBT community, we are talking about another group, just like many others, based on racial minority status, gender minority status, you name it, that have been a focus of marginalization. And I would, make the comment that has been the victim of, more of a societal willingness to discriminate against this group in more modern times relatively to other groups. For example, as I, growing up as a kid in the 80s and 90s, LGBT Americans had very, very few rights in our country compared to the gains that have been made in the last 20 to 30 years. So a lot of this stuff that we're talking about here in terms of civil rights achievements for LGBT Americans are very, very contemporary. This is a group that's, on the whole, historically, had been absolutely denied any type of economic, political, or social equality. Victims of horrible stereotyping, you name it. So, I'm not going to get into the details of that, but understand that America was a nation that was more than willing to discriminate and create negative stereotyping for LGBT Americans for a very, very, very long time. Not to say that it's been, totally eradicated, but, there have been a lot of achievements in the last 30 years. And let's start getting into some of those. For example, the case of Lawrence versus Texas in 2003 is going to be very significant because what this is going to do is overturn state anti-sodomy laws that were still in effect in parts of America. And basically what anti-sodomy laws serve to do, for lack of a better explanation, is to make it, effectively illegal to be a homosexual, at least a homosexual male, in terms of how these laws were being enforced. And so, understand that by 2003, the Supreme Court has, reached a point where they have said that, having these anti-sodomy laws in the books are clearly an attempt to deny people their right to privacy. That the ability for someone to engage in consensual sexual relationships with other consenting adults is really somebody's own personal business, and that the government cannot interfere with that. And so basically, to kind of boil this down, what Lawrence v. Texas does and what makes it so historic is that it basically makes it legal to be gay in this country. Which is an unbelievably important achievement. It validates the existence of this group of Americans. So that is a very, very significant foundational achievement. But obviously, just the right to be gay is certainly just the beginning. There's a whole, galaxy of issues dealing with civil rights for LGBT Americans that still, need to be addressed. And one of those areas of focus is access to serving in the military. Now, once again, when I was a kid growing up, if you were someone that was of the LGBT community, you were not allowed to serve in the military, period. If you were a homosexual or assumed to be a homosexual, you were removed. You could not serve in the military as a homosexual. In fact, you would be asked that as part of your interviewing process. But in 1993, President Clinton will be willing to change some of those policies, or at least by contemporary standards, try to move at least more of a moderate direction with the don't ask, don't tell policy. Now, you got to understand, change in this area took some time. But as somebody that was in high school when this came out, this was a big, big deal. The idea that for the first time the military was no longer allowed to ask if somebody was a homosexual. That's the don't ask part. However, the don't tell part was that you could not publicly be a homosexual in the military. So the idea being was that if you are gay, keep it to yourself. And as long as you keep it to yourself, then you can serve in the military. Now, At the time, as I told you, that was a big deal. It was seen as an achievement. Now, by today's standards, it's pretty repressive. The idea being is you can be gay as long as you're in the closet. So if you're at a USO dance and you're a heterosexual, you're more than welcome to bring your date of an opposite gender. But if you are a homosexual, you would not be welcome to do so. So obviously, still some inequity for sure. It's going to take almost another 20 years before President Obama will effectively change the order to then allow for homosexual soldiers to serve openly in the military. And no, 2011, that's just, about 10 years ago. So once again, when I talk about these achievements as being contemporary, they are very contemporary. All of these things have been happening in my lifetime. So, and yeah, I know I'm old, but still pretty contemporary stuff. Now, when we talk about LGBT issues, it is very easy to kind of lump all of these issues together. And if you dive more into the complexities, obviously there are issues regarding civil rights that are unique to gay men or lesbian women, and then especially when you're talking about transgender Americans. And, the idea being is, how do you address an issue in terms of civil rights, in terms of someone that is asserting that they are of a different gender than what their biology stipulates. And so this, in many respects, this is kind of the new frontier in terms of civil rights issues in this realm. And to give you an idea of kind of, how this is still an area of, the frontier, so to speak, President Obama allowed for transgender Americans to serve in the military openly. But when Donald Trump became president, he rescinded that executive order, not allowing any additional transgender individuals to serve in the military. He did not kick out existing transgender soldiers, but would not allow any additional ones. And then with Joe Biden being elected president, he rescinded Trump's executive order, therefore going back to the Obama policy of openly allowing transgender soldiers to serve in the military. So understand that a lot of these issues that are affecting transgender individuals are unique compared to other issues within the LGBT community. So that's important to keep in mind. Now, another area of focus over the last generation or two is the idea of marriage equality. When I was growing up, the idea that a gay couple could legally be married and recognized in society was just beyond contemplation. Really, it was just seen as unfortunately, it was just viewed as absurd when I was a kid. But we have seen a lot of movement in that direction. Now, to give some context for this, as we start to get into the 1990s, there starts to be more of a social acceptance for LGBT Americans. We start to see more positive images of LGBT Americans in television, movies, sports, et cetera, politics a little bit. We're starting to see some gains made. And as you're starting to see a little bit more of the acceptance of the existence of gay Americans, we start to, of course, see the very next rational step of, well, if I'm gay and I'm kind of accepted as being gay in America, why can't I enjoy the right to marry someone that I love just like a heterosexual? And that's where we get into the issue of marriage rights for gay Americans. Well, as this is starting to become an issue, Congress gets very concerned about this and passes what is called DOMA, the Defense of Marriage Act, in 1996, which, as far as the federal government was concerned, stipulated that they would not recognize homosexual marriages as legal marriages. Now, I know some of you are thinking, well, hey, marriage is a state issue, not a federal issue. Anyway, that's true, but understand, marriage is not just simply a statement of officially being in a relationship. It is also included lots of financial matters, medical matters, things like that, where the federal government would be involved. So, for example, if you are someone that is the spouse of someone receiving Social Security, well, the person that was receiving Social Security passes away, their spouse then gets that Social Security. If you were a heterosexual couple, if you were a gay couple, at the time that did not apply. So the federal government having a stance on this is significant. What we started to see then in response to DOMA is states starting to move in the direction of allowing gay couples to get married either by state Supreme Court rulings or by state legislative action or by state referendums by the public. And so we started to see a few states. I remember there was Hawaii and Massachusetts and Minnesota. I mean, you started to see some of these states, a few at a time, starting to allow for homosexuals to be legally married. But, by the time we get into, the early Obama years, it's kind of about a half and half kind of thing in America. And then it raises the question of, okay, what do you do if somebody is married in one state and then they live in a different state after they get married? Does that legal marriage that was performed in one state, is it allowed to be recognized, or does it have to be recognized in that other state? DOMA said they didn't have to do that. And, this brings us to the case of Bergafeld versus Hodges, which is actually a Cincinnati-based case. Bergafeld and his partner, John Arthur, Jim Bergafeld and John Arthur, were a Cincinnati area couple, got married in Maryland at the time where homosexuals were legally married, so they had a legal marriage certificate, but lived in Cincinnati, and the state of Ohio did not recognize that as a legal marriage. Well, when Mr. Arthur got sick and died from ALS, his spouse, Mr. Bergafeld, wanted to be able to have the same, benefit rights as a widower, if you will. And the state of Ohio denied him that. And that then led to a lawsuit regarding, the right to be able to be legally protected as a gay couple, in terms of marriage. We know that the 4th article of the U.S. Constitution allows for full faith and credit in terms of legal documents among states. So once again, if you're a straight couple traditionally, if you got married in Nevada and Las Vegas and then you moved to Ohio, you're still married in Ohio no matter what. Well, basically, Bergafeld versus Hodges is going to rule that must also apply to gay couples as well that get legally married. So today, no state can deny a marriage license to a gay couple. That's going to be a very, very big, famous achievement for gay rights. However, though, there's still questions regarding other issues regarding, equal access and civil rights in terms of, for example, what do you do in terms of how do you kind of jive civil rights for gay Americans with some of the deeply held religious beliefs under the First Amendment that many individuals have that believe that, homosexuality is a sin, that promoting homosexuality, supporting homosexuality is a violation of their faith. And that has raised some very interesting questions. For example, does this mean that in the future that a church will be forced to marry a gay couple within their church? Not just a civil marriage by the state, but within a religious context? Will this force, for example, someone to cater a reception for a gay wedding, even though it might be against that caterer's religious beliefs? These are important questions that are still being considered. Additionally, we also have, going back to issues of transgender individuals, questions about, for example, bathroom policies. We've seen from, the Obama and Biden administrations clear differences of opinion versus the Trump administration in terms of, making accommodations for those students that, wish to use the restroom of the gender they identify with versus the gender that they are born with. So these are still issues that are up in the air. We still don't really have clarity on these issues, and these are going to be important matters moving forward. But one thing that we do have some clarity on, finally, and this is just from 2020, once again, very contemporary achievements here, is that in the case of Bostock versus Clayton County, Georgia, we saw the Supreme Court rule for the first time that LGBT Americans, just like people of color, just like ethnic minorities, just like women, etc., cannot be discriminated against by their employer. So in other words, you cannot deny someone a job on account of being gay or fire someone on account of being gay. Now note, there are some interesting, considerations in terms of, this clearly makes sense if you're talking about the county government in Georgia, but what about the Archdiocese of Cincinnati? Does that apply there? So there's some interesting applications of this, but this is a major achievement. In many respects, you're taking parts of the Civil Rights Act of 1964 that clearly did not include LGBT Americans, and you've applied some of that in this ruling. So understand, LGBT American civil rights have come a long way in recent years, but obviously still many issues to consider moving forward. So we will leave it there for today. We'll see you next time. Bye-bye.